And yeah, thanks for the introduction. You already mentioned the main problem when we think about generative AI, and this is the exclusion of information. And so to start at the beginning, basically, we have the new Product Liability Directive, and it is already has been adopted on the European level and is currently in the transposition phase, meaning that the member states are transposing the directive into national law. We already have a proposal in Germany, for example, if you are interested in more details on the national level. So the topic today is generative AI, but we have to start with traditional exclusions that risk the application of product liability to generative AI. And those are the exclusions for information and also for services, as the directive calls it, services as such, which is quite vague. We will look at it in more detail. And there is a strong conceptual overlap between those two exclusions. That is also important. You see, information and data are typically provided as a service. So also generative AI outputs, data, information can be excluded as information, but also as services as such at the same time, right? Yeah, and that's why we risk a liability for AI generated text, visual, and audio content, and more specifically, one use case that we will look at in more detail, generated advice, expert advice, and here the use case medical diagnosis, which is of course very important in whatever jurisdiction. And we will see to find some answers here, we will have to go through detours, basically. We will look at the exceptions and try to define the exceptions and then find counter exceptions, basically, right? So I'm just warning you, it goes a bit like this here, serpentine, to find some result that is somewhat convincing at the end. And this starts off, the thinking about the exclusion starts off with the tensions that they create when we look at other concepts in the directive. There are many actually, and these are the four big ones basically we start off with. Is the most important, of course, the inclusion of artificial intelligence and software in the scope of the directive. That is very pronounced inclusion, and that is the biggest tension probably if you want to exclude many generative AI services from the scope or generative AI products. Then also the inclusion. So we have now compensation for the loss of data, which is a very new concept, also extends the material scope of European product liability significantly. And then a subtopic, which is also highly interesting, the question of functional information, which is included traditionally. That means it started off with architectural plans, basically. Said, okay, this is functional information, it should be included in the directive. And then we also have a completely new liability for everything that is a related service. There's a huge scope of including data and software into the scope. We will talk about this concept in more detail. So you see there are even contradictions towards the traditional exclusions of information and services as such. So we start off with the first exclusion for information. Here you have the complete recital, which is nice because it starts off also with the inclusion of software, right? This is also the starting point when we think about AI. The directive basically says artificial intelligence is a kind of software. That's why it's included in the scope. And importantly, it also says that it is included irrespective on how it is provided to the user. That means it can be standalone software or AI, but also software as a service, right? So this is there's obviously a direct contradiction to the exclusion of services when we say that software as a service, SaaS, is included, right? That's just a starting point for software. But then we come to information, and the directive says information is not to be considered a product. And the directive should not apply specifically to the content of digital files, such as media files or ebooks or mere source code of software. So that is a somewhat helpful definition of information when it comes to creative content and entertainment content, but otherwise it remains vague. In my understanding, as we will also see throughout the talk, it will likely mean that excluded types of information are mainly semantic knowledge. And with that, I mean, if you start at the lower end with raw data, and then you go higher up in kind of a hierarchy of information, semantic knowledge is knowledge that humans directly consume or are able to consume, right? Text in a book. And I believe that's the main goal of the exclusion, is to exclude semantic knowledge to be consumed by humans. And also entertainment content, because that you can kind of read from the recital, media files and ebooks. So the argument is strong that creative content, entertainment content is excluded. However, we will see that much is left unaddressed with this definition. For example, should data be included? Is data information or not? And there are some arguments, for example, that point in the direction that data is not included, since it does not represent semantic higher knowledge. So take one step back. So if you think about information, we start thinking about information under product liability, we will see even traditionally that there are exceptions to this exclusionary principle, right? So we start off very basic with product warnings and product instructions, which are information, and they're not excluded from product liability, right? Warning defects and instruction defects is a classic type of defect under product liability. So that's a starting point where we see, okay, information is not necessarily excluded, even traditionally, from product liability. And this becomes even more, this will become more problematic with more intense human-machine interaction. When you think about a robot at home, for example, that provides you information for safety reasons all the time, it will announce its next action or other aspects. And we see that this, with human-machine interaction, becomes more questionable to define the borders of safety information and services and other information that supposedly should be excluded from the directive, right? Then regarding data, or more specific, I like the term raw data because it's clearer actually. In my view, can be included in the directive. The directive does not mention it directly when it excludes information, but we can make this argument based on other concepts in the directive, most specifically the inclusion of all related services. So software has related services, data provision to a software system or an AI system, and all these kind of systems are included. And those systems typically are data provision, right? Then there is also tension with the exclusion of information following, I already mentioned this, functional information, which started off with architectural plans and now also includes digital manufacturing files. So that is information, but it is conceptualized as functional in a technical sense. If you're an IP lawyer, you will think about the technical effect, for example, that information can have. This is quite narrowly only mentioned for digital manufacturing files, but I think this should be extended to include all type of data specifically, or information that is only used for technical purpose, training data. I can use all, even semantic knowledge can become functional information then if I use it only for a technical purpose, for training an AI model specifically. But functional information, being very specific in the directive for digital manufacturing files, always requires a connection to physical harm to be relevant, right? A digital manufacturing file that, so you produce physical products with physical risks, and that's the concept of functional information. Then the exclusion of information also creates tension with, I also already mentioned this, the inclusion of data loss, a compensation for loss of data, more specifically the destruction or corruption of data. If I lose a digital file, I will get compensation, which of course raises the question how to define the value of such digital assets. But this also includes intangible assets, meaning cryptocurrencies, for example, or e-money and these kind of things. This opens up a whole new scope of product liability, actually. Very relevant for the financial sector, but not the topic of today. But you see that if I exclude information and then include harm to data, there are likely many cases where I would then have to reject compensation because a data or information led to the harm to data, right? So the harm of data is covered, but the source of harm, information, is not covered, right? So kind of also we see a tension rising here. Okay, so what about the exclusion of services? Again, here you see the recital. The directive should not apply to services as such. And there's not much more information given what these services as such are. What, however, is now covered by the directive are related services. This is a big topic. If you can just read it, or I explain to you, these are all, I already said it once. If you have a software, an AI product in a device, for example, you will have different data services or other kinds of digital services used in the application. And as long as you can make the case that the manufacturer of the device is in control of this third-party service, there are many different types of criteria mentioned in the directive, what constitutes control. It's too complicated also to go into these details here. But all these kind of services, data provision to your device will all be covered, which extends product liability significantly for software and for data. So also, if you remember, I said data is probably included in the directive, right? And this is the main argument. Okay, so again, think about the exclusion of services as such. The directive does not apply to services as such. Okay, we can define software and AI as a product. That's what the directive does. We saw this in the other recital before. But then again, we will deliver services with the software or the generative AI or whatever type of AI is. These will be services typically. So since there's no clear definition of services as such in the product liability directive, we have to look at other places in European law to define services, which services are as such and are therefore excluded from the scope. If you look at the Digital Content and Service Directive, which deals with European warranty law, it will tell you these services that we use every day, creating and processing, storing, or accessing data, for example, online, all these services we use every day, they are covered by European warranty law, and excluded are because there are already other liability frameworks in place for these things are expert advice in healthcare, in legal services, in financial services. Those are excluded from the warranty directive, the older directive. And I make the argument, since we don't have a definition in the product liability directive, we can kind of align with this service definition and therefore exclude expert advice mostly. Right? These are human tasks, traditional human tasks that experts providing advice, and they have their own liability frameworks, and that's why it makes sense to exclude them. Also because if you think about the first exclusion of information, they are semantic knowledge. And that's the other argument why they are excluded. So they're excluded as information, more specifically semantic knowledge, and services as traditional services as such. And that creates tension specifically with the inclusion of software in the AI broadly announced, the inclusion in the directive. That creates tension specifically because software as a service is supposed to be covered. And already explained, related services are in the covered by the directive. So how much room is actually left for services to be excluded? And that's also why I came to the conclusion that only traditional expert advice is excluded, because all related services, everyday services that we use are included. And what is left is expert advice being excluded. Okay. So these are the principles that we have to think about, that we start off when we think about product liability for generative AI, basically. And so I kind of repeat a little bit what I already said today, just to summarize. So typical common low-level data processing services like formatting files or enhancing content and these kinds of things are covered. And specifically where you risk a loss of data, corruption or destruction of data, this will not be a problem. Also, when you think about the service definition from the other directive. Then you have entertainment content, audio, video, literature, creative content or entertainment content. These things are clearly excluded from the scope of the directive. As I said already before, there's not so much a discussion of whether these things should be excluded or included. They are excluded. Also, software code only in the sense of information. Don't consider this to exclude software, but only the software code, basically in a copyright understanding, basically, is also excluded. And why? You can ask simply because in this context, creative content, entertainment content, we don't have any risks involved that have traditionally been covered under product liability, right? What is excluded are expert advice, as I argued before, that also relates to data analytics with generative AI or other AI systems, agentic AI and social AI, and we will cover this more specifically on the next slides. We can just generally ask the question, are these or such types of generative AI excluded as expert advice, because we're close to expert advice or semantic knowledge always when we deal with these things. And we will see most importantly is for the counter exception is the idea we will include everything in the directive if there's risk of physical harm, because that's where we're coming from with product liability traditionally, and also from kind of the other side of the coin, everything that leads only to pure economic loss always has been excluded, and that will stay being excluded. The most important case, so again, one step back, if we want to exclude expert advice, legal advice, financial advice, medical advice, or healthcare advice, and specifically medical diagnosis, that is so I would be happy to exclude expert advice in general, but then you realize medical diagnosis would be excluded, which is a highly important case. And how can we argue that it is included? Why not exclude it as semantic knowledge or service as such? Well, there are many arguments that you can come up with, that you can bring, that are to some degree convincing. Unfortunately, the directive doesn't tell us ultimately whether it should be excluded or included. So you can, the community basically has different arguments, but the majority opinion certainly is that it should be included in the directive, even though we don't have a clear answer. So we'll today name you some of my arguments. So we first of all start off with the risk of over-reliance on the AI system. Again, you think about a physician taking advice from the generative AI system. And we will see in the future more and more a weakening of the human in the loop, likely. So that is the risk that is involved with this new risk that is involved with these systems. Then you can make the argument in a situation of medical diagnosis and medical decision making, you have information that is functional. It's maybe not, it doesn't have a technical effect in the narrow sense, but since it is connected to a physical risk, it kind of has a quasi-technical effect in a larger sense, specifically if you compare it to legal or financial advice. Then you can also look at safety regulation. Product safety regulation doesn't differentiate between whether you consider software as a product or a service. The same rules in medical safety regulation will apply. It is agnostic towards this distinction between product and service. And also when you look into jurisprudence in Europe, there's not a clear-cut case that tells you that this is not possible to include. So as a summary, again, for expert advice and specifically medical diagnosis, I argue we can include knowledge. So it's just the counter exception, right? Inclusion of knowledge where physical risks exist. So on the other side, excluded remain financial advice, legal advice, everything connected to the liberal arts more specifically, not just because they don't include physical risk, but also they typically lead to pure economic loss. And nothing there has changed there. Pure economic loss is excluded, and that kind of supports the argument that the differentiation between physical risks and non-physical risks. Okay, so what does it mean for, again, think about medical diagnosis and a physician using an AI system to come up with his decision? We will then have to balance the responsibility between the generative AI and the physician or the hospital. And this will depend on the risk level and on the control that either party can exert, right, as a very high-level principles, right? If the higher the risk, I make the argument in an article, the higher the risk, the more safety is required of the system and less responsibility of the operator of the system. So safety of design of the system needs to be better when high risks are involved. This can also be supported by the recitals in the directive. And when you look at control, of course, there are very different cases where the operator has more or less control, or also the manufacturer has more or less control, or other parties involved, like providers in between. So this will be very use case specific, depending on the specific case. But these are the general principles, right? It's risk level and it's control of the involved parties. And then you can just say, okay, operators will remain partly responsible for compensation where they are reasonably able to validate the outputs. They have to validate the outputs. For a physician, he has to read medical literature and check whether the result of the generative AI makes sense, for example. They have to apply the system in the correct context for the purpose of the system, which also then includes having the correct inputs to the system, right? These are all things in the control of the operator. And if I apply it, misuse the system, there will naturally be no product liability on the side of the manufacturer. And in many cases, I think we will have an apportioning of responsibility ultimately between the manufacturer and the operator, which has different, you can again start talking about different sub cases here, but we will not go into this. The only thing that you always have to think about is a natural person, the operator, the physician in our use case, his responsibility will end with his control, because in European law, at least, the physician will be judged based on his fault and not under product liability, right? So we have other principles that apply, and we have to balance our product liability defect concepts with the fault element that applies to the operator. This is, of course, a big challenge, and I can't give you a general answer or anything. This is something that will depend on the use cases, and we will definitely have to think more about specific cases. Then some short remarks on AI agents and agentic AI and social AI, and then I will finish off with the conclusions. So AI agents and agentic AI are typically result in pure economic loss or data loss. Examples are the deletion of business data by an AI agent, conclusion of unwanted contracts or random transactions. For example, these are all pure economic loss or data loss related, also depending on how broadly you want to define data loss or data corruption. Then you can move things out of the pure economic loss exclusion into data loss. This is another problem that I'm thinking about. I can't go into detail here. It's clear that the directive does not cover pure economic loss, but the loss of intangible assets. So that means AI agents in financial sectors. This is highly relevant now under product liability. If I use a financial service to process intangible assets and then the data is deleted, you will be liable under the directive. And you could also make the argument, this is still a question, but I make the argument also if I lose access, for example, to an asset, that should also be covered under data loss and this, data construction and data corruption. So on the other hand, if you have investment advice, here I'm mostly thinking about the financial sector, investment advice will remain excluded because it's a traditional expert advice and service as such, as mentioned and explained before, and this will remain excluded because there is no physical risk involved on one hand, and because there is the typical result will be pure economic loss, right? So that is the main argument for exclusion. Agentic AI, I'm not sure if you are familiar with the distinction between AI agents and agentic AI. Agentic AI, more or less simplified, means you have many AI agents that you combine to do more complicated tasks. And in this regard, you will see the problem if the operator or the user can freely combine different agents. It is very difficult to argue for a liability of the manufacturer or the software developer of the individual AI agent, right? Because the system is defined by the operator to a large extent. This is also reflected by the directive by excluding liability for systems where the operator substantially changes a system. And I see this is this is not necessarily the idea of the directive to think about agentic AI, but this will certainly apply to some extent at least. And then you can only expect some basic safety by design measures from developers. But if you look into the discussion about agentic AI, you see a lot of research on safety in this regard. And so it's likely that in the next years, we will see more safety systems that are reasonable and have to be implemented by every provider of agentic AI. that means ultimately they will not be, for now, they are not responsible for compounding effects of multi-agent systems. This is the last domain I want to short talk about, social AI. So we have social relationships created by generative AI or larger AI systems. And we all think about psychological harm in this regard, right? And psychological harm now is explicitly covered by the directive. Not thinking about generative AI necessarily, but psychological harm, where you can show harm in a medically certified manner by a physician. But there is compensation for psychological harm. It's also interesting, I think, because we see historically more and more extension of compensation for different types of harm. And with psychological harm, I think we are now only starting off probably. Maybe we'll see in the next 30 years more compensation in terms of immaterial harm, psychological harm, and these things, even beyond a medically certified harm. And here again, so there are basically two cases I'm thinking about. Take any chatbot giving medical advice. If it's medical advice, again, applying the idea, if physical risk is involved, we should cover the system under product liability. I already made this argument, and that's why a system giving medical advice is covered by the directive, and also naturally by liability, tort liability in the member states under tort liability. Nothing new here. And on the other hand, you have a system not providing medical advice, but rather starting relationships with users. This is the infamous case, much discussed today, creating so-called parasocial relationships. Most specifically, they reinforce users' maladaptive behavior or beliefs and leading them to suicide, for example, as the worst case. And there I make the case, okay, these are relationships, and relationships are not services. And you could maybe come up with some services that provide, or some providers to provide such services by humans, but for me that goes beyond the idea of a traditional expert advice, or let's say in psychotherapy, for example, where you already have regulation that covers these fields, either safety regulation or liability regulation. So parasocial relationships are not covered by existing frameworks and are therefore not services as such and excluded. That's why they are included under product liability. However, in this whole field, when you start looking into it, you will see, since there are many different forms of harm, with suicide being the worst case, but also psychological harm like in mid-level and other lower level forms of harm in this context, we will quickly realize that we need more exchange probably between the psychological community or psychology community and the legal community to come up with standards that the courts can apply. We could start off with literature on human-based unacceptable behavior, for example, mobbing and these kinds of things. Or I think we rather need some rethinking of the whole topic, because, as I said before, I see an extension of liability slowly to include more and more types of psychological harm. And this will also lead to other questions, for example, having to prove damage with new presumptions in a directive that I'm not talking about. This is also highly questionable whether these new presumptions can apply in the context of psychological harm, because it follows very different rules as physical machines where product liability started off. Okay, these are my conclusions. The exclusions of information and services are losing ground as long as we are in the digital context. And this is, despite all the vagueness, I see in the legal community in Europe clearly more support for broader application of liability for AI, for generative AI, despite these problems. Then also some other principles that I kind of found while thinking about all of this is we have to distinguish between raw data and higher semantic knowledge when we think about product liability in this context. We should also always think about technical functionality and technical effect when you come from IP law, for example, and physical risks involved. And the main point is that expert advice and creative content remain excluded from the scope as long as they are traditional human services with no physical risk involved, right? Legal services, financial services, and you can even include creative content service and these kind of things into this kind of notion, non-physical human services. Agentic AI often operates because of its multi-agent complexities outside of the idea of control or an initial purpose that the software developer defined for such a system, and that's why it's very difficult to grasp these systems with product liability. And regarding social AI, I think we will still require, it's not just a problem of AI, but it's rather a problem of psychological harm, immaterial harm also, that we still have to come up with more stringent concepts for compensation here. And this becomes even more problematic with social artificial intelligence systems providing such information and content. So much from my side. Thank you very much for listening to the complexities of European law. I'm very much open for questions from your side, for discussions. Also, I would love to hear some insight from Hong Kong, the perspective from Hong Kong lawyers or Chinese perspective. Thank you very much.